Who's arguing for the appellant?
Scott Smothers on behalf of the appellant.
Are you ready?
I am.
Come up to the podium. Don't be shy.
Scott Smothers on behalf of the appellants. In this case, first of all, I want to thank you for giving us the honor to bring this before you this morning. May it please the court. In this case, Your Honor, we're dealing with a situation where the plaintiff below failed to prove that they lacked an adequate remedy at law, and they failed to prove that they would suffer irreparable harm if the trial court failed to grant the injunction that was later granted. We have briefed these matters adequately in our briefs, and I want to not continuing to pound the dead horses that we've created in our brief. But
go ahead then. You wanted to start with something?
yeah, the primary issues, Your Honors, is that the two that I just brought, an injunction only issues to prevent irreparable injury when the remedy at law is inadequate. The plaintiff below didn't bring really any argument about their adequate remedy at law or the inadequacy of the remedy at law. They could have sued for damages and they chose not to do so. They only sued for an injunction.
What do you claim the adequate remedy would have been that the trial court didn't recognize in this case?
The adequate remedy at law would be money damages. So these are...
Explain how you equate money damages with noise.
Yes, Your Honor. So there's cases cited, for instance, the Exxon case cited by the appellee, that there was a continuing nuisance that was found for the Exxon Corporation.
Who was the nuisance?
I'm sorry?
Who was the nuisance?
The nuisance had to do with noise and other things, but the homeowner in that case lived 700 feet away from a separation plant. This was the first DCA case. And the first DCA implicitly found that money damages were sufficient to adequately compensate the homeowner in that case.
Because the noise couldn't be abated somehow?
They declared it was a permanent nuisance. In theory, it could be abated. You could tell the separation plant to stop making the noise, but they didn't do that. They simply said, well, what's the value of the home? So they could look at what's the diminution in value of the home, or they could look at, if there was a business, what would be the rental value of the home. In that case, under those facts, it was the homeowner's primary residence, so they didn't look at how much could you rent your house for. They looked at what's the decrease in value of the home, and they used that as a determination.
We didn't have that. There wasn't, I don't like that analogy, to be honest with you. I just think there's too many variables to use that as your best argument. You've got another argument besides that?
Well, there's two primary arguments, Your Honor. In a way, there's three.
So on that though, sorry, judges, are there a lot of cases which abatement of nuisances, noise and whatnot have been enjoined? I mean, because of the difficulty in quantifying any sort of damage or inadequacy of monetary damages, I mean, how does this distinguish from them?
This distinguishes, Your Honor, in that, in this case, this is primarily a commercial activity by both parties. In most of the nuisance cases that you're dealing with noise and
Primarily, but
it's almost entirely a commercial activity. As testified by Mr. Garcia at trial, he
does
bought,
quantifiability come into the room?
I'm sorry?
Does quantifiability come into it?
Yes.
How are you supposed to quantify the diminution in value or the business damages? I mean, it has to do with how many times someone writes a negative review.
I can think of many ways to quantify it. So what we're dealing with here, Your Honor, are...
But aren't there cases that talk about that difficulty being sufficient to place this within the category of cases for which there's no adequate remedy of law?
They either had to bring proof of quantifying their damages, or bring proof as to why it was impossible to quantify the damages. If you review the transcript at the trial level, they made basically no attempt to do either.
Some of the arguments that I read and that I'm making, it's
Well, I can explain.
really difficult to determine how much a negative review impacts a business.
I don't think it is, and I can explain why. There's multiple ways that the plaintiff could have brought evidence to the trial court about their damage. They could have argued a diminution in value of their property. They could have argued a diminution in the nightly rental value of the property. They could have in some way quantified the number of people that complain about noise and then fail to return as a repeat renter.
How can they quantify what that effect on people who would have rented but didn't?
They testified, Mrs. Garcia testified at trial that 60 to 70 people complained about noise. Almost all of their rentals are through Airbnb. All of the communications between the owner and the tenant in Airbnb are within Airbnb. You go back to all the people that complained and said, I heard too much noise, I didn't like it, I'm not coming back. You're going to print all those people and you're going to say how many came back, how many didn't come back.
Aren't you electing how the plaintiff should have proceeded? Doesn't the plaintiff have the right to elect remedies in the first instance? So they could have gone that route and bring a lawsuit every time they get a tenant that says, we don't want to live under these conditions or rent under these conditions, or they could say, hey, let's just get a permanent injunction, be done with it. Apparently, the trial court went the permanent injunction route. I assume the other argument was made below by your client?
Well,
You didn't elect the right remedy?
I directly asked on cross-examination about the damages. You know, Mr. Garcia, what are your damages? And the answer is pretty telling.
You would have been happy if you had a judgment entered against you in each and every case going forward.
Well, whether we're addressing the damages or whether we're addressing the
You
injunction,
say there's no damages because it's a temporary disturbance.
they didn't address their damages. They didn't quantify their damages. Of course, there's an argument that there's a damage, but that doesn't mean that they brought any evidence or testimony about it. So when I asked Mr. Garcia at the trial, in cross-examination, tell me, Mr. Garcia, what are your damages? How has the activities of the gym damaged your business? Quote, so it hasn't in terms of damage, in terms of losing money or anything, because we've been able to minimize everything that has happened up to this point. And it continues. To get an injunction, which is a drastic remedy, you have to show irreparable harm. And
So were they there first before the weightlifting club came into being?
the gym was there first.
Pardon me?
The gym was present first.
Okay, so
The houses were-
was going on and the people that opened up next door coming after the fact.
So just to recap some of the facts, the houses were there for 70 plus years, but a person was living there and didn't complain and passed away. The Garcias purchased
They
it
turned it into an Airbnb.
after that, while my client was already open as a gym, and they remodeled the properties. They did a beautiful job remodeling the properties. To some extent, the problems that I believe that the appellees have in this case have to do with how good of an Airbnb host they are. That goes to the answer that Mr. Garcia gave. He doesn't really have damages because they've done a good job of mitigating.
So the question is the trial court bound by this case law that says you gotta sue each time you have a diminution in value?
Well, the trial court is required to determine whether or not the plaintiff has proven an inadequate remedy at law. They have to look at the damage. They have to decide if there's a irreparable injury that can't be addressed by money damages. And even if it gets past,
So the standard is an abuse of discretion or
it's abuse of
by
discretion.
law?
It's
So if
abuse-
Abuse of discretion, then you'd have to prove the trial court abused its discretion in finding inadequate remedy, et cetera.
Both briefs accept that the standard of review is abuse of discretion. We do make some argument, Your Honor, in our brief that when there's no facts that are being weighed by the trial court to get to the legal determination, it's a little bit different. There's no dispute that my client operates a gym that makes noise. There's no dispute that they have a successful Airbnb business 14 feet away from the back door of my client's gym. That's not in dispute.
Well, the trial judge in this case just said you can't drop the weight set during night hours. Is the gym open at night? Is that even a factor in this case?
It's open from early in the morning to around 7 p.m. at night. But
The trial court, the abuse of discretion, may not be readily apparent at first how that plays into the question I asked, but in the law regarding injunctions requires comparative,
weighing the consequences and
equitable principles, balancing relative conveniences, right? I personally, when I think of that, I think that in the area of abatement of a nuisance, I find it hard to apply that literally because there is always going to be a mismatch, an imbalance of equities. Because if you abate a nuisance, the abated party, respondent, defendant, whatever, is going to be affected more adversely. They're going to be more inconvenienced because the whole point of abatement of nuisance is to convenience the party bringing the nuisance abatement action and inconvenience the party, right? So this, can you use this equitable principle of balancing the relative conveniences, I'm just reading one case that I have in front of me, to argue that you can't get an injunction at all if there's some mismatch in the conveniences of the parties?
Well, not that there's some mismatch, Your Honor. There's not simply a mismatch. In this case, what we have from a totality of the evidence is that the plaintiff is wildly successful at operating a short-term rental business. He testified at trial that he doesn't really have damages because they've done a good job of mitigating any problems. When somebody complains about noise, they come out and they apologize and they say,
Let's assume for my question, that there's been some harm alleged and that we've decided it's irreparable, okay? Let's presume that.
Okay.
So then what I'm talking about is this, I'm talking about the entry of the injunction itself and perhaps the scope of the injunction. This balancing of equities
Right.
that applies universally to all injunctions has been applied on a few occasions that I've found, a few, in recorded case law to the abatement of a nuisance. But isn't abatement of a nuisance inherently inequitable insofar as the imposition of convenience on the party whose nuisance is being abated is going to be much more severe, and perhaps there will be the other party is only going to have their inconvenience alleviated. So it's always going to be imbalanced. Would you agree with that?
there's always going to be an imbalance. The question is how much imbalance?
Right, so isn't that question and a matter of abuse of discretion?
We don't disagree about the standard of review.
Right, so you agree that in every abatement of nuisance case, one party not only is going to feel like they're more inconvenienced, and I'm not discounting that it is an inconvenience to them, and it's personal to both parties, and it's serious for both parties, but in an abatement of a nuisance, if the trial court has decided, or the finder of fact has decided that the nuisance has been established, one party is going to feel and also literally have been treated inequitably. Inherently, they have to stop what they're doing to some extent. The other party only gets a benefit, so it's inherently inequitable. So at what point, A, will you concede that inherent inequity can't vitiate the entitlement to an injunction altogether? And then once you concede that, which I assume you readily would, how is it an abuse of discretion here to say that in this instance, when the evidence seems to have suggested that all the activity requires the dropping of weights at some point, that this is an inequity that requires some sort of reversal to reshape the injunction?
There's an abuse of discretion in multiple ways. The trial court failed to require that the plaintiff prove any level of damage. All the case
I'm not
laws.
talking about damage, I'm presuming damage.
If I could.
Oh, okay, so you're saying this is part of the balancing.
This is part of the balancing. We're asking why, under an abuse of discretion standard, should this court change what the trial court did? The trial court abused its discretion because it failed to follow all the case law. There's a fair balance of case law in Florida discussing nuisance and injunctions in general, and what the chancellor sitting in a court in equity must do. It must first see proof of damages or proof of why they can't quantify the damage. So if we have a homeowner living beside this gym and they're living there and sleeping there every night, and they're woken up every morning at 5 a.m, I don't know how I would quantify that. What's the value of your sleep, right? So, but that's not what we have. We have a commercial enterprise. It was relatively easy under the facts to start to quantify what the damage was. They had to quantify damage. Next step, they have to show that remedy at law would be inadequate, and therefore the injunction must issue. But even if we get past those two things, now we have the balancing that you're talking about. And so, sure, there's always going to be it's going to be inconvenient to the target of the injunction, of course. In the case at hand, it's like this. How do we know that? Because Mr. Garcia testified to that at the trial. What are your damages? Well, I don't really have any.
Now, let's say you presume for the sake of my discussion, which I want to emphasize that I don't care about that damages. I don't think it applies. Okay? I'm trying to ask a different question. I get it. You don't think they prove damages. You don't think that they prove they can't quantify damages. If I presume for the sake of discussion, they're damaged.
Sure.
Then my question is, why is the scope of this injunction something that violates the requirement to balance equities?
Well, you have to look at the harm, the relative harm to the target of the injunction versus the relative benefit to the seeker of the injunction. And the plaintiff here would receive almost, what's the benefit received by the plaintiff? Apparently, some people may not complain
That's
about
noise.
noise because the testimony and the evidence at trial also showed that there's other noise events that have nothing to do with the gym that exceed the noise levels of the ordinance. There's a CVS from here to that wall. The back of the gym is from here to that wall. They're boxed in by commercial activity. There's a bus stop 30 feet in front of the house.
I guess what I'm saying is, you've conceded that the fact that there is some inequity is inherent in an abatement of nuisance, and therefore it doesn't per se vitiate the entitlement to injunctive relief. And I'm asking you, how does that affect our ruling then? We're not going to reverse the injunction. Based on that, I mean, maybe you want us to, and you can argue now why, having conceded that, we should just say there should have been no injunction. But I'm asking, why are the specific requirements, the specific actions being enjoined, why do those somehow violate the comparative analysis in the case law of balancing equities?
Before you answer that question, I just want to let you know you have 4 minutes of rebuttal time that you have begun.
Thank you, Your Honor. I'll try to answer the question succinctly and then hopefully still reserve 2 or 3 minutes. The court was required to balance the equities, the relative harm to the defendant versus the relative benefit. And what I'm arguing is that in this situation, under these facts, they're incredibly disparate. They're not even close. Will the plaintiff get some benefit? Of course they'll get some benefit. Will the defendant have some harm? Yes, but not in the case law that we see. It's not like a little bit of harm. She'll be out of business. There's no way you're having a gym where you can 100% of the time prevent any weights from dropping. There's not even a quantification in the injunction about what does that even mean.
Doesn't that militate in favor of that is a tragedy for one party. But if there's a finding of nuisance, and if the factual findings are that in order to abate the nuisance, you can't do a certain activity because doing that activity will inevitably cause the nuisance to persist, should it be the concern of the trial court or this court that tragic result will happen for the party whose nuisance is being abated?
It is absolutely.
In other words, if you can't abate the nuisance without that level of harm to the defendant, the plaintiff should just go home and say, I'm sorry, you have to live with the nuisance. That's what it sounds like.
They should seek the remedy at law, and that's exactly what happened in the Exxon case in the first ECA, and that's exactly what happened in the New Mexico case cited in our brief.
So if the balancing test is unworkable, you say, go home, you have to live with the noise, and you have to bring an action for damages. That's what I'm going to read in the Exxon case?
That's the Exxon case, and that's also the case we cited out of New Mexico where there was a manure plant next to a homeowner.
You have to live next to manure because they put the manure plant out of business, and therefore we can't what if it's, a nuclear, anyway, I'll let you see your time.
I think you've got 2 minutes left. If you stop now,
I'll stop now. Thank you, Your Honor.
May it please the court, my name is Paul Kavonis and I represent the appellee. With me is Mr. Garcia. He is one of 2 of the members of the appellee LLC. I want to begin by highlighting the fact that the testimony at trial that the gym violated the Indian Rocks Beach noise ordinance on multiple occasions was unrebutted.
So, no, before you leave that thought, it's not relevant that the nuisance was there or.
Yes.
I assume that's where you're going with that, okay.
Correct. So there is no defense of coming to the nuisance. And Your Honor had asked that question, and it bears mentioning that when this gym opened, the principal, Ms. LeBlanc, who is here, was aware that the activities of the CrossFit, the general activities of this extreme weightlifting and dropping weights from height cause noise and vibration. She knew that, as she testified, because she had come from another facility in Clearwater where this was a problem and they had experienced numerous complaints. So coming to the nuisance is not a defense. First in time, first in right does not apply. Case law is
So in
clear.
other words, the judge on an ordinance violation could have shut them down altogether.
Absolutely.
But he found a happy compromise in his discretion to get this fair to both sides.
Right. So my colleague argued to the court that this proscription of dropping weights from 6 p.m. to 7 a.m., which constitutes only 2.5 hours.
Okay, we've read the briefs, it constitutes only 2.5 hours, we've read the briefs, but they're making the case, and I mean, the evidence could perhaps support that they would have to shut down their business. So based on the imposition, let's presume for the sake of discussion, since that's how we left it.
Sure.
Let's presume for the sake of discussion, or just hypothetically, that an abated party, that the abated party would have to shut down all operations in order to comply with the injunction. And let's presume on the other side that given the evidence that the dictates of the injunction are the minimum required to abate the nuisance. Are they correct that then the only option is damages? In other words, you can't abate a nuisance if the inequities are so imbalanced that it would put the abated party out of business.
To be blunt, them's the breaks. That's tough. That's tough on the party who is being enjoined. The fact of the matter is that if, as you indicate, and again, I don't buy the premise that it's going to put them out of business, but let's assume it does, then that's the natural result of enjoining.
Right. It's a natural result of the injunction.
Right.
And the other side has already conceded that they're obviously, essentially the argument he conceded, and he can correct me if I'm incorrect, he conceded that there's some imbalance in the inequities inherent in a nuisance abatement. Obviously, one side's being abated, it is hard for them. They're not, otherwise lawful activity, but it creates a nuisance. It's hard. They can't do something that would otherwise be lawful. And the other side is getting all the benefits. So he's conceded that. But his point is, and he's relied on the case, the Exxon case, that if at some point the inequities are so imbalanced, then the party bringing the action has to live with the nuisance and sue for damages.
No, and I'll push back on that. There's no cases which would suggest that. And getting to this adequate remedy at law issue, basically two components for the court to consider.
Why does an Exxon, by the way, first off, why does an Exxon support that?
Exxon was essentially really a taking case almost. Okay, Exxon had this plant which so greatly diminished the value of all these properties that Exxon was basically tagged with damages associated with the values of their various properties. I mean, that's basically what Exxon, an environmental type case, that's what Exxon stood for. That was not the type of nuisance in which the parties were expected to live with in perpetuity for as long as they respectively own their properties. The remedy there was Exxon had to pay the aggrieved parties the value of their property. Now, the key here is, in this case, is that we have a recurring, ongoing nuisance. And Judge Valente hit upon this when he had asked my colleague if my client would then be required to sue for every violation. Clearly, in a situation where you have that type of ongoing nuisance, suing for every single violation, by virtue of all the cases that are cited in our brief, lead one to the natural conclusion that there is an inadequate remedy at law. That's the first point. The second point is this. My clients, and by extension, their commercial guests, and by the way, this distinction between commercial and private interest is, in this context, is irrelevant. And we have an important case that I just want the court to be aware of. It's cited in our brief. That's the Mayflower case. Hotel versus nightclub, right? And hotel says nightclub is being too noisy, the guests are real rowdy. What does the Florida Supreme Court say in that situation? Well, the guests, the owners of the hotel, the Mayflower, have the right essentially to quiet and peaceful enjoyment. The guests, which is a commercial interest, can also, their violation of that or the violation of their quiet and peaceful enjoyment can also form the basis of injunctive relief. So again, the distinction between commercial versus private in our situation is immaterial. The case law is clear that if the result is putting someone out of business, if that is the minimum in conjunction with a minimum injunction, one that's narrowly crafted, then so be it. There is no situation in which the aggrieved party is required to live with a nuisance found by the trial court. And there's more than competent and substantial evidence to support the fact that this is in fact a nuisance. I know you've read the brief, so I'm not going to belabor the point, but this is not a situation where we're dealing with a hypersensitive homeowner who is complaining about a barking dog or the use of a lawnmower at odd hours. This case involves extreme noise, extreme vibration.
So we understand the evidence. How do you apply the balancing test then? And there are cases, I'm not saying there are a lot, but there are cases that apply a balancing test to an injunction to abate the nuisance. So how does it work then? And if you're saying that it could be the most imbalanced case imaginable, and here both parties, one party's gonna be aggrieved because they both have legitimate businesses. The most imbalanced case imaginable, and if that's what it takes to abate the nuisance, you gotta enter the injunction.
If a party does not have an adequate remedy at law, they cannot establish their damages.
Okay.
There's only two possible outcomes. Number one is they have to live with, like in this case, an unrebutted a violation of the noise ordinance, or they sue for injunction. Okay, injunctive relief. There is no way to have a damage calculation based on the loss of quiet and peaceful enjoyment. I have found no cases.
So presuming that the remedy law is inadequate, unquantifiable, again, I'll ask a question, maybe my question is too drastic. But how do we apply this balancing test then? We do apply to the parameters of the injunction?
Yes,
We
yes.
apply to, is it imposed in order to help this court and the trial court assess whether the injunction itself is narrowly tailored enough, or whether it's too broad, it's broader than needed to abate a nuisance?
In this instance, the balancing of conveniences, phrase used by the court, is going to be applied in the actual words of the injunction. This is what the court did.
Okay, so why are the words in the injunction not too draconian? And you read the briefs, we read the briefs, why aren't the arguments that it's too draconian, why don't they have purchase?
The injunction language that is complained of states that they can't drop the weights between the hours of 6 p.m. and 7 a.m., even for these so-called emergencies. I discussed the fact that these are not true emergencies because it's just part of the normal routine. These gym members are exerting maximum effort, dropping these heavy weights from height. 2.5 hours out of the gym's daily routine, daily schedule. Ms. LeBlanc testified under oath that she would be able to comply with those types of restrictions. There was no testimony whatsoever at trial, none, that this type of restriction would put them out of business. And common sense and logic tells us that it would not put them out of business. 2.5 hours out of their daily operating hours. It is.
That's even presuming that the use of weights requires the dropping of weights, which was not absolutely established by the evidence one or the other, but
Right.
if we do presume it, you're saying that still wouldn't be such a deleterious effect on their business that it wouldn't.
Correct. Absolutely.
So was there any evidence about the ability, I mean, I know that they presented evidence that, it was perhaps too draconian because they can't account for accidental drops. But is there any evidence about, you know, the fact that it was a blanket prohibition and it should have allowed lightweights? Is there any argument or evidence on that one?
Yes, but here's where it gets muddied a little bit. The appellant, throughout the entire course of the trial, characterized every instance of weight drop as an emergency, as if it was some sudden and unexpected event. If you looked at the videos in particular at the two thumb drives, I mean, this is pretty dramatic, right? People, again, exerting maximum effort, dropping it from height. That is precisely the type of activity that can be curtailed. There can be weight use. Plenty of people who engage in this type of activity use weights at gyms across the country without dropping the weights. In fact, up until this fad of the CrossFit routine, people did not drop weights. It was considered unsafe.
Okay, but it says even in emergencies. So let's say they say, look, we're not gonna, you know, the trend is CrossFit and usually requires dropping weights, but don't do it if it's an emergency, don't hurt yourself. So is that too draconian to say?
No, it's not too.
Is it necessary? Maybe that's the point. Is it necessary to make the nuisance to say you can't even do it if it's an emergency?
I would say no, but the reason why the court put that into the judgment is because, again, of this testimony that all of these weight drops were emergencies. The court was simply trying to address the fact that this is really not an emergency. So you can't use that as an excuse to drop weights. And if, in order to comply with the injunction, they have to curtail all weight use during that period of time, that's not an unfair result. That's not an overly draconian result. It is also important, to note that that again, Ms. LeBlanc was aware when she opened this gym that these were known problems, and this is why CrossFit gyms are typically not located in this type of mixed-use district. They're located in warehouse districts. We point this out in the brief. This is a well-known problem in the industry. This goes back to what Judge Valente was talking about in terms of coming to the nuisance, who was there first. But fundamentally, the trial judge crafted the most narrowly possible injunction that he could have done in this situation, right? 2.5 hours during their operating day, late at night, early in the morning. I don't think under any of the applicable cases that can be considered an unjust result or a result which places too much burden on the gym. I've seen no cases, and nor have any cases been cited, which stand for the proposition that that type of restriction, that limited restriction, violates this concept of balancing the conveniences. And this kind of circles back to the abuse of discretion standard. The court is well aware of that standard. The court considered the balancing of interests. All of these arguments were made at the trial court level. This is why the court constructed this very narrowly tailored injunction. The only other point I want to make is concerning the and I touched upon this earlier, this and Your Honor asked about this concept that it's going to put them out of business, okay? Again, just to kind of circle back and close this up, the testimony at trial was that that was not the case, that there could be compliance, that it would not adversely affect the business to the extent that it would require closure. And with that, I have nothing else to add, Your Honor.
What's clear from the argument in the brief and from the argument in counsel is that the appellee absolutely does not care about weighing the conveniences in this case. They have argued in their brief and today that it just doesn't matter. If one side goes out of business and the other side gets this much additional benefit from it, that's just the way the cookie crumbles in this case. And what I find funny is that two of the cases relied on in the brief and just now, that's not what happened. In the Mayflower case, the Supreme Court of Florida in 1940,
Sorry, go ahead.
in Mayflower case, the Supreme Court of Florida in 1940 did not shut down the nightclub that was making noise right beside the hotel. They awarded money damages. In the Exxon case, a case that was brought as a nuisance case, they didn't shut down Exxon, they awarded money damages. Those are the two cases that counsel just cited in his argument. And I'm going to point the court to Harrisonville versus W.S. Dickey Clay Manufacturing Company, which is a United States Supreme Court case from 1933, wherein the Supreme Court said, where substantial redress can be afforded by the payment of money and issuance of an injunction which subject the defendant to grossly disproportionate hardship, equitable relief may be denied, although the nuisance is indisputable. The nuisance in the Exxon case was continuing in nature, it was permanent. The nuisance that was in the Mayflower case was not continuing or permanent. They could have shut down the nightclub and said, yo,
I don't want to interrupt you, Mrs. Smother, you've got less than a minute to finish.
you can't operate between 2 a.m. and 5 a.m. or whatever to try to abate the nuisance for the hotel next door. That's not what happened. And in this case, what we are not conceding is that the trial court didn't engage in reversible error by failing to require that the plaintiff prove some level of damage or prove why they can't quantify damage. And then how is it irreparable harm? There is no irreparable harm because Mr. Garcia conceded on cross-examination that he really has no damage. He's been inconvenienced by the fact that he has to go and apologize to people that complain about noise. And if you review all the reviews on Airbnb that are publicly available at VRBO and Google, nobody's complaining about the noise.
His time just expired, so I want to thank you for coming today and well argued. Thank you.
Thank you, Your Honor.
Mr. The estate of Bristow versus Stanley, thanks.